Welcome to the DWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the DWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 186 of the DWI Guy podcast. On today's episode, we are talking about discovery. That's right, we're talking about discovery. Honestly, one of the most important topics when it comes to defending DWI cases. Is it required in district court? Is it not required in district court? Does it matter? How do we get it? What do we use it for? These are some pretty important questions that we need to be asking. And I am in the fortunate position because of the offices that we have across the state to see a number of different discovery practices from county to county, different pockets of the state doing different things when it comes to turning over discovery. So today and for the next couple of episodes, we are going to be talking about discovery in the district court process, and particularly concentrating on paperwork coming from the officer, primarily from the charging officer. Notes, handwritten or typed, dash camera, body camera. What are the ways that we get this discovery from the officer? Now, before I kind of go through today we're really just going to talk about some different mechanical ways of getting the discovery. I'm talking about 10 ways to get discovery from the officer. In some of our subsequent episodes, we're going to dive in deeper than we're going today into a few of these various ways to getting discovery. But I think that this is a conversation that really needs to be had on a large scale, both across the state and in particular jurisdictions, especially if you're in a jurisdiction where the DA's office is not doesn't have an open file policy, is not good at getting discovery into your hands, or even worse, is resisting giving discovery to the defense. These are some important topics for us to think about and then talk with our local colleagues about how do we change policy. Now, I'm going to start off today with a little bit of a story based on a line from a favorite show that I had growing up. My dad introduced my brothers and I to the Sharp series. The Sharp series is a series of episodes, almost like feature-length films, actually. I think it was originally done maybe through the BBC, but it basically is a series centered around the Napoleonic Wars and concentrating on a character, Richard Sharp, who basically kind of through heroic action goes up through the ranks of the British Army. And it's really kind of his story, so to speak, with the backdrop of the Napoleonic Wars and his adventures. And there is a moment in one of those videos or episodes. I think it was more in the video line back then than episode, but in one of those films, his superior officer, Major Mungo, basically is telling him about a secret mission that he is going to be going on, and is not giving him a lot of details about this mission. And Major Mungo gives this famous line that we all hear so often of, Sharp, what you don't know, don't hurt you. And I'll try my best Sean Bean response here, Sean Bean English accent response of what Sharp responds. And he says, beg pardon, sir, but in my experience, what you don't know usually gets you killed. And that line is always stuck with me. I love that line. It's really delivered in a very humorous way. I did not do it justice. You got to go watch the Sharp series. I think they're on YouTube now. So if you want to have a really good time watching watching these films. Sean Bean kills in this role. So just know that you're going to be in for a real treat. Look it up on YouTube. I can't remember the order that the videos go in, so you have to like do a Wikipedia search of the order of films, because it doesn't tell you episode 1, 2, 3, 4. They're all named Sharps something, and but there is a list in terms of watching them in an appropriate order. I think Sharps Rifles is the name of the first film. Killer episode or video, but all of them are great. So, but anyways, that response of what you don't know usually gets you killed applies very much to criminal defense lawyering. If we want to do a good job for our clients in the courtroom, if we want to deliver a solid DWI defense, and we do not have the officer's notes, we do not have the officer's narrative, we haven't watched the video, if there is any on the case, dash camera, body camera, we're doing our client a major disservice. And if we're not looking into that, we're doing a major disservice. If we have the opportunity to look at it and we're not, we're doing our client a major disservice. This is where cases are won or lost. This is where cases are won or lost, is in the discovery phase of doing a really good review of the officer's body camera, dash camera. And I'm going to say something that, everybody listening to this podcast already knows, but when a client calls and tells us what happened at the time of a DWI, first of all, we have to take that with a grain of salt. And secondly, it's not necessarily all that helpful, because, 99.9% of the time, your client is not testifying at trial. So no matter what they tell you, that information, generally speaking, is not going to come out directly at trial. Now, it may come out in the form of you being able to more appropriately cross-examine the officer, do digging ahead of time, site investigation, whatever it might be. But it's not going to help you in terms of actually being able to attack the charge. So all of that goes to say this: you need to do as good a job as possible trying to get discovery on your case. And what we're going to talk about today is 10 ways that you can go about getting discovery. So I'm going to start off with way number 1, and that is in a situation where you have open discovery, voluntary discovery. Now, you might think, okay, well, what the heck are we talking about this? If I have open discovery in my county, then why is this even important? Well, it's important for 2 reasons. And that's reason number 1 is that in counties where there is open discovery, first of all, are you accessing it, and how easy is it to access that, right? So some counties will say, oh, we have an open file policy. But then if you say, can I have the video? Oh, well, let us request it from the officer. And then it is literally like request after request, week after week, waiting for video discovery to come back. On the flip side, there are counties where you can get that discovery back immediately. So why is it important for us to kind of start with and talk about voluntary discovery? Well, first of all, it's important because if you're in a county where there is not an open file discovery policy, the state does not voluntarily give discovery in terms of officer's report and any video on the case, the real question should be, how do you go about changing that policy? And what is the purpose of discovery? But let's think about this in like a civil case for a second. Why is there such open sharing of discovery in a civil case? As we know from law school, the question isn't like, are you giving discovery that's, evidence that could be used at trial, but really is more of a broad question of, is the request likely to furnish, discovery that could be used at trial, or that could allow somebody to find information at trial. Like it's a very wide and broad allowance in terms of civil discovery. And there's a reason for that. The reason for that is that the purpose of civil discovery is to avoid trial. That's the whole purpose. It's to promote settlement. You cannot settle cases if each side is guessing as to what the other side's game is. You basically, what is the purpose of civil discovery? It's to basically make people show their cards. Lay your hands down on the table. Instead of this guessing game and guessing match of like, hey, what's the other side holding? Show your cards. Okay, well, it looks like you're going to lose if we go to trial, or it looks like you've got a bad hand, or it looks like there's some good issues on your case and bad issues. And all of these things are important in terms of reaching a settlement. That's the value in a criminal case of the defendant having discovery. I think so often when in counties where there is not an open file policy or not a voluntary sharing, there's this idea that, look, if we give the defense, our video, body camera, whatever, trials are going to increase. The amount of cases going to trial are going to go up. And I would argue to you that it's the opposite, or at least that it should be the opposite. If you show body camera, dash camera, notes, reports, and defense has an opportunity to look at those and review them with their client, either it's going to be generally apparent on video that there's no issue to attack, or that there is some sort of issues to attack, and sometimes so strong that the state, after looking at it, might say, you know what, we're going to dismiss this charge. Now, that's rare. I have not seen that a lot. Generally, more often than not, after looking at the video, defense is going to say, there's not a case here. There's not anything to contest or challenge here. And so I think having a conversation, again, first of all, with your local bar, if you're in a jurisdiction that does not allow for open sharing of discovery, but then secondly, sending a group of your local bar to the local DA to basically say, look, we need to have a better open file policy. We need to be able to get access to videos, body camera, dash camera, and that is ultimately going to help you all. It's going to eliminate more cases. It's going to allow for cases to be in a position of being handled sooner. There's going to be more trust in the process and outcome. We need to get discovery, and it's going to benefit ultimately you. So those are things to look at. The other thing is, if you're in a county where there is a open file policy or a voluntary discovery policy, but it's still difficult to get the discovery that's supposed to be open. It's still difficult to get a copy of the officer's report and body camera. That is a systematic problem happening at the district attorney's office at the local level. Again, there are counties in our state where if you ask, several weeks after the charge has been made, if you ask for the officer's report and body camera, you are within a week of that going to get the officer's report back. You're going to get the video back, and it's going to be immediate. Some counties that we practice in have this ready to go, all in a paper packet, the full discovery report with camera attached. Others do it electronically by email, but they get it to the defense attorney requesting it immediately. Now, how are they able to do that? Well, they have figured out a system with their local agencies on getting discovery from the local agencies. They've made it important to their local agencies on DWI cases. Hey, we need this back to get to the defendant so that we can fast track these cases for plea or for trial. So if you are in a county that purports to have open file policy when it comes to DWI cases, but you are having a difficult time getting that, typically that is just a systematic problem in terms of how is the DA collecting that. So go in and make a suggestion. Say, hey, what could we do, jointly? Is there something that we can do as the defense bar to help you get this information more quickly from your agencies? Again, emphasizing, if you all get this, if you, the state, the prosecution, get this to us more quickly, we can more quickly have a meaningful conversation with our client about the, issues in the case, whether positive or negative for us, but we'll be ready to handle the case sooner if we get this sooner. If it takes us 5 court dates to get the video, you've now wasted, the court's time, the clerk's time, judge, had people going back and forth in and out of the courtroom, the DA looking at a case, not knowing whether this case is for trial today. And all that could be avoided just by getting all of the meaningful information back on the case within a short period of time. So these are questions that we really need to discuss at the local level, and we should be constantly pushing to get discovery if you can't, and then fast track it if it's allowed in your county. So way number 1, voluntary discovery, improve the process. Okay, improve the process. No matter what county that you are in, there's ways to get that information faster. Be a part of the solution. Don't gripe and complain that you don't have discovery in your counties. Be a part of the solution for getting it back. Be a part of the solution for getting it more quickly. This can happen. It happens in certain places across the state. So it's not a question of can this happen? It's a question of why is it not happening? So way number 1, voluntary discovery. Way number 2, make copies of the DWI and civil revocation files. I'm not going to spend a lot of time on this, but there are nuggets that you can quickly get access to in the DWI and civil revocation file. If your client, doesn't have the ability to get you a copy of his warrant, a copy of the breath test ticket, or even if they do, go make a copy of the DWI and the civil revocation file, because there's going to be paperwork in there connected to the case that may be more legible, or you may not have in your file whatever you've received from the client. Way number 3, through a formal discovery request process. If your case, and we may take a deeper dive into this in a episode down the road, but if your case has a felony attached to it, then you have basically a case where the original jurisdiction is within the superior court, and you have the right to have discovery. I had a consult the other day where my client was charged with felony possession of marijuana along with impaired driving. That's a case that we have the absolute right to get discovery back on. There's no questions about that. So if you have a situation where your client is charged with felony possession of drugs, felony death by vehicle, felony fleeing to elude arrest, whatever the associated felony is, if you have a case where the original jurisdiction is with the superior court, make sure that you include a formal discovery request at the earliest possible stage so you can get that information back. Way number 4, request Brady material. And we're definitely going to take a deeper dive into this. So I'm going to kind of keep this one a little bit short and sweet here, but definitely make a request for exculpatory material. This is something that we really should be pushing hard on across the state in a county where there is not discovery being given over. Because in almost every case, there is something exculpatory that is in either the video or on the report, right? Something that is going to be helpful as to the weight. So we're going to do a deeper dive into the Brady motion side of things, but this is something that we should definitely be pushing it and using as a way to try to kind of flex the defense bar's muscles, so to speak, on getting discovery voluntarily. If we're pushing hard enough on these issues, you can use a Brady motion, in my opinion, to make the state do more work than if they just gave the material over to a requesting defense attorney in the first place. So ultimately, in a lot of places, why are you not getting discovery back? Because the prosecutor's office is lazy. They don't want to be burdened with collecting discovery from the local agencies. They don't want to have the burden of turning that over to the defense bar. So it's just basically like, hey, discovery is not required of district court. Don't ask us about it. But if it was more difficult for them to not give you the discovery than to give you the discovery, most of the time that the state is going to take the path of least resistance on that front. So make it more difficult to not give you the discovery than to give you the discovery. Brady motion is one way to do that. And you're constitutionally allowed to get that information. So you should absolutely be exercising that constitutional right on your client's behalf. Number 5, subpoena power. There have been a couple times early on in practice where a local agency, after the state had basically said, "Hey, we it's open file. We'll be happy to get this to you." Either A, didn't get a response from the local agency, or in a couple of cases, the local agency just said, "Hey, we're not turning this into the DA's office." And ultimately, it was kind of like, oh, okay, well, we're going to get this, from the state. But I basically just got tired of waiting around for it, and I got a district court judge, to sign a subpoena and sent that to the local agency. And lo and behold, wouldn't you know it, we got what we were asking for within a very short period of time. Use the subpoena power. Why would we not use the subpoena power? I mean, this is something that we absolutely, again, should be taking advantage of, especially if you're in a county where the district court judges want to get this information. And I think that a lot of district court judges understand the importance to both sides, for the criminal defense lawyer to get the officer's reports, body camera, dash camera. If we're thinking about a process that is fair, a process that is open, if we think that the court system is supposed to basically showcase all of the kind of ugliness of a situation and allow the fact finder to fully see what's going on, it makes sense for the criminal defendant to have the opportunity to review the state's case against them. So I think, generally speaking, most judges think, I don't know why the state is hiding something. Why are they not turning this over? Even if it's not statutorily required, right? There's nothing in the statute on a district court case that says that you cannot give it over, right? So there's nothing that says on district court matters, the state shall not give information to the defendant. And in fact, that's why many counties have open file policies and say, hey, whether we're required to do this or not, here's all the information. But there's nothing that basically prohibits the state from sharing information. So judges, I think, generally speaking, are thinking to themselves, why are we not getting this information into the hands of a defendant? Let's give them the information about the situation. So use the subpoena power. Take advantage of that opportunity, of that tool for getting discovery back. Number 6, the video release statute that came out several years back on law enforcement agency recordings. This was something that early on, after it was passed, I think it was around like 2016, 2017, I started using that statute to get video, body camera, dash camera back from agencies using that civil process. And again, we're going to take a deeper dive into this. But again, in Buncombe County at the time, there was not a good process in place for getting video. There was not an easy way to do it. So I just said, hey, well, let's let the court be in charge of having this turned over. I filed several motions. I had hearings with both the city attorney and the county attorney over these things. And ultimately, really where we got to was I had a conversation with one of the assistant DAs that basically said, what are you trying to do with this? Like, why are you filing for these things? And I just basically said, I'm just trying to get the dash camera and the body camera video. That's all that that's why I'm going through all of these hoops. I don't like filing motions and, wasting the county and the city attorney's time and having to schedule hearings and sitting in Superior Court. I don't really like doing that, but I need to be able to see this video. And he was like, oh, okay, well, yeah, we'll figure out a way to fast track that. And he was able to help get streamlined a process for requesting that video online. And it really made a difference. I mean, it really made a meaningful impact. And sometimes you just got to push a little bit on an issue in order to get the remedy, to get the ultimate outcome, which is just getting the opportunity to see the video of your client on the night that they were charged. So use that statute. Again, we'll probably take a deeper dive onto that statute here in the next couple of episodes, because I think it's an underutilized tool for getting the most important piece of information, really most important discovery, the most important evidence, which is the video evidence. I mean, of all of the evidence you could get from the state, video is really the most powerful because it doesn't lie. I mean, it literally, if you've got, video that shows your client, has audio of your client, it literally is like being on scene in the moment with the officer. And again, as to why anybody would think that the defendant should not have that, at their fingertips prior to trying a criminal case is just beyond me. I honestly cannot think of any good reason why a defendant should not have a copy of their body camera and dash camera prior to their case being called for trial. It is absolutely nonsensical, in all honesty, to not have that at the fingertips of the defendant. And so again, we need to be pushing on these issues because it's critical to assessing whether or not you've got a good case for trial. And it's absolutely critical to trying a case to have this, ready to go, have watched it, have reviewed it, have taken notes about it, base your cross-examination questions around this. So we'll do a deeper dive onto that. Number 7, request a civil revocation hearing. You can get a lot of discovery through the civil revocation process in some counties. After a civil revocation hearing is requested, the magistrate judge or the district court judge is really just looking at the file, at the affidavit of the chemical analyst and the other documentation that's in the civil revocation file to determine whether or not the civil revocation was appropriately entered. But in some counties, the officer is subpoenaed and called as a witness at that hearing. Take advantage of that. Again, if you're in a place where you're not getting discovery, ask for that civil revocation hearing. If the officer is there to testify, you now have an opportunity for discovery. You can do cross-examination at that time and get a sense of where things were, what field sobriety tests were done. You can ask if they reviewed their narrative ahead of the hearing. You can ask to come up if they did and look at that if they have a copy of that with them. So take full advantage of that civil revocation hearing. Number 8 and related is absolutely take advantage of a refusal revocation hearing. This is basically a deposition of the officer on your case. If you've got a client that is got a refusal and this is going to be a case that goes to trial in terms of the criminal case, use that refusal hearing as your deposition. Contest the refusal. You can get a copy of the transcript of the refusal, but you have the hearing officer that is asking a very kind of like laundry list set of questions and really is in a lot of spaces kind of like not really going too far beyond checklist in terms of questions, but then you basically have kind of like open season in terms of asking questions about the stop, the arrest, what was going on at the time that chemical analysis was requested. I mean, use that as an opportunity to cross-examine the officer and then get a transcript of that cross-examination of the officer's questions. You've got them locked in at that point. Okay. I mean, and you can ask them in the revocation hearing again, did you take notes? Did you review those notes? Do you have those with you? May I look at the driving while impaired report that you did in this case? I mean, all of that information is going to be incredibly useful in the case going to trial. So don't miss that opportunity to depose the officer. And again, you may actually also be able to overturn the refusal revocation, which is ultimately maybe a bigger win than winning on the DWI, but certainly you're going to get discovery. So that's the worst case scenario, is you get discovery in that refusal hearing. Best case scenario, you win the refusal hearing and potentially are able to maybe use that to keep the refusal piece out of evidence down the road. At the criminal trial. So number 8, use the refusal revocation hearing. Number 9, talk with the officer. Okay, so this is somewhat like voluntary discovery in number 1. That was more with the DA's office. This is now like voluntary discovery in talking with the officer. Show up at the court date. The officer's there. Hey, can you tell me a little bit about what was going on in this case? Do you mind if I take a look at your notes? Do you have any video on this case? Can we watch the video together? Step out and talk to the officer about the charge. If you do not have the opportunity to look at discovery ahead of time, use it as a means of investigation on the court date to step outside with the officer and ask for the discovery back, and use those same talking points. Hey, my client's trying to figure out, whether we're going to try the case or not, but I don't know what's going on. I haven't seen anything. The state hasn't turned anything over to me. I haven't seen your report. I haven't seen the video. I don't know how all this looks. So, if there's a way that I can look at all that, I can meaningfully assess whether or not we should go to trial. But since I don't know, I guess we just go to trial and I figure out in real time, is this a case worth trying? Because that's the only other opportunity that is left to my client. Explaining that to the trooper as well. And then if you do that time after time with the same officers repeatedly, they're going to say, hey, actually, this guy used my notes the last time to go talk to his client. They came back 10 minutes later and entered a guilty plea. I mean, that's the value of having the discovery, is you can basically not have the default be trial. The default is trial until we get discovery. I mean, that ultimately is the mindset that you should be going into it with. If you're, saying anything to the client about, hey, we're considering a trial, it's got to be for trial unless you have the discovery back. I mean, there's just no sense in pleading without that, because how would you know what to meaningfully do on the case? Obviously, sentencing levels and that type of thing factor in, but on a level 5 case, there's just no reason not to have that be the default position until you've gotten the discovery back. And then finally, number 10, you can basically use the district court as a discovery process for superior. Right. So if you're in a county where you're not getting any information and you're not getting, the information that you need back on the case, use the district court trial as a discovery opportunity for superior court, and then appeal cases. Because again, ultimately, if we're not getting the information that is really in the interest of justice to get back, which is discovery on DWI cases, the officer's notes, body camera, dash camera, again, it really is it adverse to the interest of justice not to give those things over to the defendant. And so we're the protectors of people's rights, the criminal defense bar. We are the protectors of the Constitution, we really need to make a concerted effort individually and collectively as a local bar to do everything in our power to get that back. So again, number 10, use the district court trial, asking through cross-examination, detailed information, record your trials, record your district court trials so that you have that captured. I have had district court trials transcribed for Superior Court so that I can use that in Superior Court for cross-examination purposes. Really use that as think about it, if you're not getting this, think about it as a deposition. This is the opportunity for me to prepare my case for Superior Court since I'm not given the opportunity to do this at district court. Number one takeaway from today is this: get together with local members of your local bar. Get together with the members of your local bar and figure out a way to obtain open file discovery policy if that's not in place in your county, or if that is the case, figure out a way to get discovery faster. Figure out with your local bar members how you can go to the DA's office to improve the speed of which you can get discovery, and put it out there as an opportunity to help and work with the DA's office to get that information back. So those are my 10 ways to get officer discovery in district court. If you have questions about a discovery case, always feel free to call me. I'm happy to talk about a case with you, and hope this information has been helpful. And I look forward to continuing our discovery conversations here in the next few episodes.